This is breaking right now. For years, and I mean literal decades, the anti-gun lobby has rested its entire strategy on one simple assumption, that assault weapon bans were the untouchable crown jewel of gun control. They told you the AR-15 was not protected. They told you standard capacity magazines were military-grade hardware that the founders never envisioned. They told you that the Second Amendment simply did not reach that far. And today, everything changed. We are looking at a tectonic shift in the legal landscape surrounding the Second Amendment, a moment that combines a significant Supreme Court development with a Department of Justice move that nobody saw coming in this specific form, a DOJ push that could permanently dismantle assault weapon bans at the federal level. And here's the most important thing you need to understand from the very start. These two things happening simultaneously is not a coincidence. This is a coordinated legal and political moment. And today we are going to break down exactly what happened, what it means for every single assault weapon ban in this country, and why the era of these bans may finally be coming to an end. Now, before we get into all of this, if you want to support this content, one of the best ways you can do that is to hit the subscribe button right now and click the like button below. That tells the algorithm that you value this kind of in-depth Second Amendment analysis, and it pushes this content out to more people who need to understand what is happening with their constitutional rights. And I want to thank the main sponsor, Attorneys on Retainer. Look, when the legal landscape is shifting this fast, when courts are moving, when the DOJ is filing briefs, when the constitutional ground is literally reshaping itself beneath our feet, you need to know that you have real legal protection behind you. AOR is backed by an actual law firm, the Attorneys for Freedom, and they have been consistently expanding their benefits for members. 4 guaranteed attorneys for your self-defense case, the Carroll Clause, and significantly more. Use the link in the description and the code ARMSCOLAR to get $25 off your sign-up fee. Now let's get into this. If you have been following the Second Amendment legal landscape for any amount of time, you know that the Supreme Court has been dodging the core question for years. Not months, years. The lower courts have been an absolute mess on this issue. Some circuits say AR-15s and semi-automatic rifles like them are protected arms under the Second Amendment. Others say they are too militaristic, too useful in military service, and therefore states can ban them outright. And then you have courts arguing that even if these firearms are technically protected, they can still be restricted under some form of interest-balancing test that essentially lets judges substitute their own policy preferences for constitutional analysis. That conflict, that circuit chaos, is exactly what has been building enormous pressure on the Supreme Court to finally step in and fix this once and for all. The foundation for everything happening today goes back to 2 landmark decisions, and if you are going to understand why today matters, you need to understand both of them clearly. First, you have Heller in 2008, where the Supreme Court established that the Second Amendment protects the individual right to keep and bear arms, particularly arms that are in common use for lawful purposes. That is the standard. Common use. Not common use in military service, not common use in warfare, common use among law-abiding American civilians for lawful purposes like self-defense, home protection, sport shooting, and hunting. That distinction matters enormously, and we will come back to it. Heller also established another principle that is directly relevant right now. The court said clearly that the government cannot ban an entire class of arms that law-abiding citizens typically possess for lawful purposes. That sentence alone should have ended the assault weapon ban debate in 2008. The fact that it did not, the fact that lower courts found ways to root around it for 14 years, is precisely how we ended up in the situation we are in today. Then in 2022, you have Bruen, where the court completely and explicitly threw out the old interest-balancing approach that lower courts had been using to sidestep Second Amendment challenges for over a decade. Under the old framework, a court could say something like, yes, this is a protected arm, but the government has a strong enough interest in public safety that we are going to allow the ban anyway. It was a framework that made the Second Amendment a conditional right, one that existed only until a state legislature decided the public interest required otherwise. Bruen ended that entirely. The court said clearly and unambiguously, if you want to restrict a Second Amendment right, you need to find a historical analog from the time of the founding. You have to demonstrate that the restriction you are imposing is consistent with this nation's historical tradition of firearm regulation going back to 1791. That was a massive consequential standard to establish. And the expectation across the legal community was that Bruen would effectively end the era of assault weapon bans, because no such historical tradition exists. There is no founding-era law banning semi-automatic weapons. There is no colonial precedent for restricting the most popular rifle in the country. The historical record simply does not support these bans, and Bruen was supposed to make that the end of the conversation. But here is what actually happened next. And this is the part that has frustrated Second Amendment advocates for the past 2 years. The lower courts, particularly the Ninth Circuit and the Second Circuit, simply kept finding ways around Bruen. They kept upholding these bans. They kept doing exactly what the Supreme Court had told them not to do, engaging in what can only be described as legal gymnastics. Some courts began redefining the AR-15 as something other than a bearable arm to avoid applying the Bruen test altogether. Others invented entirely new categories, claiming that because a weapon could theoretically be used in a military context, it falls outside the scope of civilian Second Amendment protection. And some courts went even further, claiming that AR-15s are not arms under the Second Amendment at all, despite the fact that there are over 24 million of them currently owned by law-abiding Americans. That level of lower court defiance has now become one of the central forces driving today's legal moment. And it is exactly why the Supreme Court can no longer look the other way. Now let's break down the Supreme Court development, because this is significant and we need to understand exactly what the court did, and critically what it did not do, because both of those things matter enormously going forward. The core of the majority's position takes direct aim at the lower court framework that has been used to uphold assault weapon bans across the country, and that framework, the one that has been propping up these laws, just had the legal foundation knocked out from under it. Here is the heart of the constitutional argument, and it is important you understand this clearly because this is what everything else flows from. The majority goes back to Heller and reinforces that common use is the definitive constitutional standard. AR-15s and semi-automatic rifles like them are the most commonly owned rifles in the United States. There are somewhere between 20 and 30 million of them in civilian circulation right now. Statistics confirm there are at minimum 24 million AR-15 style rifles in the hands of law-abiding Americans. By any honest definition of the phrase, that is common use. The constitutional reasoning is straightforward. You cannot have a protected right that evaporates the moment a firearm becomes popular. You cannot have a Second Amendment that protects only obscure, rarely used weapons while allowing the government to ban the most widely owned rifle in the country. That would be a backwards, absurd reading of what the right to keep and bear arms actually means. And the court said so directly. You cannot simply label a firearm as a military-style weapon and then use that label as the justification to strip it of constitutional protection. That is exactly the kind of interest-balancing workaround that Bruen was supposed to have eliminated. The lower courts have been trying to argue that because these rifles look intimidating or because they share superficial aesthetic similarities with military weapons, the common use test does not apply to them. The majority opinion dismantles that reasoning. Justices Thomas and Alito have already signaled in their prior dissents and orders that they are not buying that argument, and the majority has now made it official. Now, and this is where you need to pay very close attention because this is the detail that is going to determine the real-world timeline of all of this. The court did not issue a sweeping nationwide injunction wiping out every assault weapon ban on the map in a single stroke. What happened is the court vacated and remanded, meaning they sent the lower court decision back down with new instructions and a clearly articulated standard that those lower courts must now apply correctly. Under that standard, these bans are going to be extraordinarily difficult, if not practically impossible, to justify. The dissent argued that states have a compelling interest in regulating these weapons and that the historical record supports some forms of restriction. But after Bruen, that argument has very little legal runway left. The historical analog test does not give you a realistic path to banning the most commonly owned rifle in America. The majority opinion says so directly, and the lower courts now have to reckon with that. Now let's talk about the Department of Justice, because this is the part of today's story that I believe is being significantly underreported, and it is just as consequential as the Supreme Court development itself. The DOJ has taken a formal legal position, and this is a stunning reversal from where the Department of Justice has stood on this issue for years, essentially arguing that federal and state assault weapon bans cannot survive constitutional scrutiny under the current Second Amendment framework established by Heller and Bruen. Now stop and think carefully about what that actually means. The DOJ is the legal arm of the executive branch of the United States government. When the Department of Justice takes a formal position on constitutional questions, it carries enormous weight, not just in the courts where these individual cases are being litigated, but as a signal of where the federal government stands on enforcement strategy, on litigation posture, and on future policy. And what the DOJ is doing here is pulling the legal rug out from under every state and city that has been quietly relying on the assumption that the federal government would stand behind them in defending these bans. If the DOJ is now saying, in a formal legal brief, that these bans are unconstitutional, that fundamentally changes the dynamic of every single assault weapon ban case currently working its way through the legal pipeline. And here is what this DOJ move also accomplishes that I do not think enough people are talking about. The brief directly addresses the historical tradition question, which under Bruen is the entire ballgame. The argument being made is that there is simply no historical precedent in this country, going back to the founding era, for banning entire categories of commonly owned firearms. The founders did not go around declaring that certain weapons were too dangerous and banning them across the board. That framework did not exist at the founding. It was not part of the tradition of firearm regulation in 1791. It was not part of that tradition in 1868, when the 14th Amendment was ratified. And under the Bruen standard, the absence of that historical tradition is supposed to be fatal to a modern restriction like this. The DOJ is now making exactly that argument, and that is not a small thing. That is the chief law enforcement agency of the United States government formally conceding that the legal foundation for assault weapon bans does not exist under the current constitutional framework. When you combine that concession with the Supreme Court's direction, you have the two most powerful legal institutions in the country now pointing in the same direction. That is not a coincidence. That is a signal. Now, does this DOJ position guarantee that all assault weapon bans fall immediately? No. That is not how the legal process works, and I want to be honest with you about the realistic timeline. What it does do is dramatically shift the battlefield in a way that is difficult to overstate. States that are defending these bans now have to do it largely on their own, without federal backing. And that matters in court. It matters in how aggressively these cases get litigated. It matters in the signal it sends to federal judges about which direction this legal wind is blowing. It matters when state attorneys general are deciding how much political and financial capital to spend defending a law that the federal government has now formally declared unconstitutional. And perhaps most importantly, it tells states like California and Illinois that defending an assault weapon ban just became significantly more expensive, significantly more legally complex, and significantly less likely to succeed. Some state governments may begin making quiet calculations about whether it is even worth continuing to aggressively defend these laws when the legal environment has shifted this dramatically against them. Now, there is something happening behind the scenes at the Supreme Court that you absolutely need to understand, because this is where the chess match becomes genuinely fascinating, and where the real stakes of all of this come into focus. If you have been tracking the docket closely, you know that cases like Duncan v. Bonta and Viramontes v. Cook County have been stuck in what looks like an endless relist loop. Duncan has been relisted for conference 8 times, Viramontes 7. To a casual observer, a relist looks like delay. It looks like the court is kicking the can down the road and avoiding the issue. But in the world of Supreme Court strategy, a relist is often the smoke that appears right before the fire ignites. It means the justices are not simply glancing at a petition and tossing it into the denied pile. It means they are actively debating the language of a potential grant. Or even more significantly, they are waiting for the perfect legal vehicle to arrive so they can issue a ruling that is not just a win on the margins, but a total, definitive, generational ruling that the anti-gun lobby has nowhere left to escape from. When you see a case relisted 7 or 8 times, you are seeing a court that is engaged, that is wrestling with timing, with language, with which case presents the cleanest facts for the ruling they want to issue. That is not avoidance. That is deliberation. And deliberation at the Supreme Court level typically precedes action. We also have to reckon with what Justice Kavanaugh said when the Snope case was denied. He made it explicitly clear that while the court was declining to take up certain cases in that particular term, the issue of rifle bans is something the court should and presumably will address within the next term or two. We are now officially inside that window. That promise has a deadline, and today's developments, the court's direction, the DOJ's historic reversal, the mounting circuit chaos, suggest that the percolation period the incrementalists on the court have been waiting for is now over. The 6-3 conservative majority is not just a collection of votes. It is a collection of judicial philosophies with different timelines and different thresholds for when to act. You have the originalist purists like Thomas and Alito, who are clearly ready to act right now. They have already written dissents from denials that read less like standard legal opinions and more like open letters to the Ninth Circuit informing them that they are in outright rebellion against the Bruen decision and that the court's patience has limits. Then you have the incrementalists like Roberts and Kavanaugh, who prefer to wait until the lower courts have fully worked through an issue before the Supreme Court steps in to settle it definitively. But today's developments have now created the kind of sharp, undeniable, impossible-to-ignore circuit conflict that makes further waiting unjustifiable. The Duncan magazine ban case is in a particularly important position right now. The Ninth Circuit has continued upholding California's ban on standard capacity magazines despite Bruen. despite the clear instruction that interest balancing is no longer permitted. And the legal framework we are now operating under gives the Supreme Court a very clean path to take up Duncan, apply the standard correctly, and finally settle the magazine question once and for all. Because there is simply no historical analog for banning standard capacity magazines. There is no founding era law that says you may only load 3 rounds into your rifle. There is no tradition of restricting magazine capacity at the founding. That argument does not exist in the historical record. It never existed. And under Bruen, that absence of historical precedent is supposed to be fatal to a restriction like this. The only question is whether the court is finally ready to say so directly and definitively. Now, if you are sitting in a state like California, Illinois, New York, Maryland, Connecticut, or Massachusetts right now, states with some of the most aggressive assault weapon bans in the country, you are probably asking yourself, does this mean my state's ban is going to fall? And the honest answer requires some nuance. It depends on how quickly the remaining legal steps move and whether the Supreme Court takes the next decisive action and issues a fully binding nationwide ruling. Today's developments are a massive step forward, but they are not yet the final step. The lower courts still need to apply the new standard. Some of them will do it correctly and strike these bans down. Others, particularly in circuits that have spent years finding creative ways to resist Second Amendment precedent, will find new methods of delay. And here's the important thing to understand. That resistance, while deeply frustrating, is actually what will ultimately force the Supreme Court's hand. Every time a lower court finds another workaround, the circuit conflict sharpens. And a sharp, undeniable circuit conflict is exactly the kind of thing that makes Supreme Court review not merely likely, but procedurally unavoidable. So let's talk about the 3 ways this plays out from here, because I think this is critically important for you to understand. And one of these scenarios should genuinely concern every Second Amendment advocate in the country. In the best-case scenario, what you might call the full send, the Supreme Court grants certiorari in both a rifle ban case like Viramontes and a magazine ban case like Duncan, consolidates them, and decides to do a comprehensive top-to-bottom resolution of the Second Amendment's scope regarding these weapons. By taking both cases together, the court signals they are not interested in half measures. They are ready to issue a ruling so broad and so definitive that the anti-gun lobby will have nowhere left to run. Think about what that means practically. States like California have built their entire gun control architecture around the assumption that assault weapon and magazine bans are constitutionally permissible. A single Supreme Court ruling that says they are not does not just strike down one law. It potentially invalidates an entire legislative framework that took decades to construct. If that happens, we would get oral arguments in the fall and a final ruling by the spring or early summer of the following year. A ruling that officially declares the AR-15 is an arm in common use, banning it is unconstitutional, and no state in this country has the authority to strip law-abiding Americans of that right. No exceptions for scary features, no exceptions for military-style aesthetics, no creative reinterpretations of what constitutes a bearable arm. That is the definitive generational ruling that ends this era of legal uncertainty permanently. That is the dream outcome, and given everything that happened today, it is more achievable now than it has ever been before. The middle scenario, what you might call the warning shot, is more nuanced but still meaningful. The court denies the pending cases, but issues a blistering written statement from Justice Thomas, joined by Alito and Gorsuch, that puts the lower courts on notice one final time. If the court denies these cases but attaches an explicit warning that the full court will address this issue in the very near term, it signals the 6-3 majority is still fully intact and simply waiting for the cleanest possible legal vehicle to arrive before they act. It would be a delay. A frustrating one, but a delay with a credible promise attached to it and a clear signal about where this is heading. Under this scenario, the fight continues into next term, and advocates need to be ready for that. Then, there is the worst-case scenario, and I want to be direct about this because intellectual honesty matters, and Second Amendment advocates have been burned before on exactly this kind of optimism. The worst case is what you might call the cleanup betrayal. Historically, at the end of a term, the court holds a cleanup conference where cases that have been circling without resolution get quietly dropped into the denied pile with no explanation and no written statement attached. If the 6-3 majority allows these cases to be relisted 10, 12, or 15 times and then denies them silently in June, it would be a significant blow to this movement. It would signal that despite everything Bruen promised, despite Kavanaugh's explicit statement, despite the DOJ's reversal, the court is still unwilling to touch the political third rail of assault weapon bans directly. It would tell the DOJ and the states that the stall tactics worked. And it would tell millions of Americans living under these restrictions in blue states that the court is content to let unconstitutional laws remain on the books while the legal process grinds forward at its own pace. It would also raise a much more uncomfortable question, one that Second Amendment advocates do not want to confront but have to. Is the 6-3 majority actually willing to apply Bruen to the most politically charged category of firearms in the country? Or is there a silent consensus on the court that some issues are simply too politically explosive to resolve, regardless of what the Constitution demands? That is the question we all have to sit with if June arrives and the cases get denied without a word. Now, I do not believe that worst-case scenario is the most probable outcome given everything we have seen today. But we have watched this court avoid this question before. We have watched lower courts openly defy Bruen for years. We have watched these cases get relisted over and over without action. So the right posture here is cautious optimism combined with genuine urgency, because today's developments are meaningfully different from anything we have seen before on this issue, and the window for action is open right now. Here's the bottom line on where things stand, and I want you to really absorb this because I think it is easy to read through all of this legal detail and lose sight of the bigger picture. We have a Supreme Court that has delivered a significant development tearing apart the lower court framework used to uphold these bans. We have the Department of Justice actively working against assault weapon bans at the federal level, a historic reversal from the traditional government posture on this issue that would have been unthinkable just a few years ago. We have multiple pending Supreme Court cases, Viramontes, Duncan, and others, sitting in conference in the most favorable legal environment they have ever occupied, and we have the specific time-bound promise Justice Kavanaugh made about addressing this issue, which is now running out of runway. What that adds up to is a convergence, a legal, political, and institutional convergence that is genuinely unprecedented in the history of the Second Amendment fight. For the first time, the executive branch, the constitutional framework established by the Supreme Court in Bruen, the mounting circuit conflict in the lower courts, and the pending cases on the docket are all pointing in the same direction at the same time. You cannot manufacture that kind of alignment. It either happens or it does not, and right now it is happening. The pressure on the Supreme Court right now is enormous. The legal framework is in place. The circuit conflict is undeniable. The pending cases are right there, waiting, and Kavanaugh's promise is on the clock. Whatever happens when that order list drops after Friday's conference, this analysis will be here to break it down for you the moment it hits. We will know whether the court uses this momentum to finally grant review and resolve this question definitively, or whether they continue to hold. And if they hold again, we will talk honestly about what that means and what comes next. This is one of the most significant moments for Second Amendment rights in years, possibly since Bruen itself. The ground shifted today. The legal foundation that was holding up these bans has cracked. The federal government has changed sides, and the cases that will settle this question are sitting right there on the conference table. The fight is not over, but the direction of travel has changed, and that matters more than anything else right now. If you appreciate this kind of deep legal analysis, hit the like button, drop a comment telling me which scenario you think plays out after Friday's conference, and make sure you are subscribed so you do not miss the breakdown the moment the next order list drops.